Any mention?
My lord, item number 12 that belongs to case Yangrai, Gabriel Yangrai. This matter, my lord, I would like to withdraw because I filed for clubbing of the FIR. Now the charge sheet has been filed, so I will.
You'll have your remedy before the trial.
Yes, my lord.
Mr. Yavin, Learned Counsel, appealing for the petitioner on instruction submits that petitioner does not want to press this application and prays for withdrawal of the same.
My lord. And item number 11, my lord. Sorry.
On prayer being made, this petition stands dismissed on withdrawal.
Apply, Your Lordship.
Yes.
And regarding item number 11, my lord, I would like to seek some more time, my lord. It's that issue where the adolescent relationship, my lord, can it be quashed or not? That subject matter is there. So I just seek some more time, my lord. 2 weeks time.
We have no objection. List after 2 weeks on the request made by the petitioner.
Highly obliged.
Please, Your Lordship. Beg to mention item number 8, my lord. This is a petition for quashing of proceedings under the Drugs and Cosmetics Act, my lord. I'm seeking 2 weeks, Lordship allows.
It's a joint prayer, Lordship.
Mr. John Priya. Okay. Your thing has become easier. Just say on the joint prayers made by the parties, it is this matter after 2 weeks.
Much obliged.
Much obliged.
May I please, Your Lordship? I beg to mention item number 6, Lordship. I'm praying for 1 week, Lordship.
This is the other side.
Sunday.
Yes.
Because no objections as such, but there's one thing that I may bring to the notice of this honorable court. My lords, this matter pertains to MLA, and in view of the judgment passed by the Supreme Court, the matters are being listed before a special bench. Presently, Justice Thank You is having writ petition criminal number 9 of 2023. So I just wanted to bring to the notice
So
of this.
it means, according to you, it should also go before the same bench.
Yes, my lords.
Just show us anything then. But then, is it not that you should place it before registry?
My lords, I am just bringing it to the notice because
No, that is all right. He says, supposing if you do not, or if it is not the proper court,
yes,
for
that
taking
is
the
that,
matter,
that is the
then this court also will not be inclined to.
yes, my lords.
Kindly verify the thing. You can so that the next day, if we can pass some.
Yes, my
order.
lords. Next day I'll bring the orders.
Is any judicial order required for? Because you see, this court cannot pass any judicial order
Right.
asking it
To be
placed before the.
yeah, we'll bring it to the
I
notice
think
of the
you should
registry.
Write it to the.
Registry. Lords, we'll do that.
That is well. Anyway, we'll just say. When shall we? What for that? For today, we will adjourn it.
Yes, my lords.
After 1
request
week,
made-
Lordship.
Yes, on the request made on behalf of the private respondent. List this matter after 2 weeks. Meanwhile, you do the things. Just should I 2 weeks or not? Yes.
Highly obliged, Lordship.
Obliged, lord.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 9, Your Lordship.
Item number?
9, Your Lordship. Lordship, I'm appearing on behalf of A.R. Pasa, who's the conducting counsel for respondent number 2 and 3, Your Lordship. I pray if Your Lordship can fix the matter after 2
You are
weeks.
making a mention on behalf of the respondent.
Respondent 2 and 3,
You
Your
should
Lordship.
go. Now, who is there for the petitioner?
Mr. J. Shila, Your Lordship.
Where is he?
Your Lordship, we have already taken his consent, Your Lordship.
Okay. When do you want it?
After 2 weeks, Lordship.
List after 2 weeks on the request made. It's all right, Mr. List after 2 weeks of the request made on behalf of.
Mr. A.R. Pasa. 2 and 3, Your Lordship.
Yes.
Much obliged, Lordship.
Lordship, I beg to mention item number 10. Lordship, I pray that this matter may come up after 2 weeks, Lordship.
Yes, madam.
Last chance maybe giving after 2 weeks.
We'll not give you last chance. If you have objection, then we'll take it up today.
It's okay, after 2 weeks, Your Honor.
Why you are asking for time?
Lordship, conducting counsel is in legs, so
But then for that you do not need 2 weeks time.
yes, Lordship. Based on instructions, Lordship, I'm just
See, instruction cannot come without any reason. If you make a mention, then you must say for what reason you want 2 weeks time.
Lordship, in that case, 1 week time may be given.
Do 1 week. Yeah.
Say, on the request made on behalf of the state respondent, list is made after 1. If you ask for 2 weeks, at least you justify what for you want. You are not prepared or some difficult.
Yes, Lordship.
But then just, you see, somebody is on the X.
Yes.
Cannot be a ground for taking 2 weeks time.
Yes, Lordship.
Okay, 1 week on the request made on the X. Yes.
Highly obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 4.
You are making a mention on behalf of?
Of Mr. S. Dota.
This is 2018 matter.
Yes, Your Lordship. He for 1 day time, Your Lordship.
What is the matter about?
This is against willful defaulter, Your Lordship. We have challenged.
What is that? He was declared a defaulter.
Yes, Your Lordship. I have no objection, Your Lordship.
Just list after 2 weeks on the request made on behalf of.
Please, Lordship, I beg to make a mention for item 3, Lordship. I'm praying for 3 weeks' time, Lordship. Oh, Lordship, it was 1 week's, Lordship. For instruction, Your Lordship, we waited.
This court has indicated on
Lordship.
the earlier occasions that this matter will not be urgent.
Because our
You take it up.
chance, Lordship, for 1 week, Lordship.
We have already indicated. We'll take it up. Rejected. We are rejected.
Simply pray for item 5, Lordship.
What is that item 5?
It's, this EPF matter, Lordship. We've informed you at the site, Lordship. We've informed, Lordship.
Who's the other side? Let's inform the other side.
Yes, Lordship.
Okay. Yes, item 5. After 2 weeks on the request made on behalf of the petition.
Highly obliged, Lordship.
Item number 1. I'm praying that Lordship may pass it over for time being, Lordship. This is Thapai, Lordship, it's unlike for division.
For a time being.
You know the body,
Call
Lordship.
it at the end of the vote.
Item number 7.
May I please, Your Lordship?
Yes.
I pray for kindly this matter at the end of the board, my lord. Mr. Khan, senior
All the
advocate,
matters we have already.
my lord, he is in TV, my lord. He is requested to kindly take up this matter at the end of the board, my lord.
There will be difficulty again. This court will have to sit in division bench also.
My
So
lord.
when that call comes, that
Yes,
also we
ma'am.
do not know. If we start, then in the midst of thing we have to leave, and then we do not know how long.
Otherwise, this matter requires only a small matter, not more than 5 minutes.
For you, it may be Mr. But then for this court, we have to get the facts and all. See.
But all we want is the documents, my lord, which have been directed to be supplied to us.
okay,
And that is only the interpretation of Justice Dingdo's order, my lord. Nothing more is required to be done in this matter.
That is, say, supposing if you say the interpretation of Justice Dindo's order, then this court may not be appropriate court. I think then you should file.
But
an
that is the
application.
only thing which is required.
See, you can do one thing. You can file an application for listing this matter before Justice Dindo, because this
But
court will-
my lord, I don't want, because if my lords also see that order, the order clearly indicated that all the documents which were seized by them have to be given to us, and that is the only thing I am requiring even today also. And as per the law laid down by the Supreme Court, the
That is all
various
right.
judgments.
We'll come to law later. Just if there is an orderly order in existence, we do not have to go to any other law. If you say that there exists already an order
Yes.
directing for supply of all the documents to you, then
And
that
they
has-
agreed to do that.
yes, then that has to be complied with.
And then another difficulty, my lord, another surprising thing which happened before the trial court was, despite the special public prosecutor saying that all are matter of record and they can rely upon the documents, and the report is not yet been filed, and yet the trial court, my lord, dismissed my application. The High Court's order was very, very categorical that once they supply all the documents, report be submitted. The trial court records a very clear finding that the report has not been filed, yet I am dismissing this application at this stage. And then the court, my lord, goes on to say that I am now known to the accused persons. I want to now recuse myself. But that order anyway can't stand in my way now anymore.
What the earlier order of the High Court required?
I kindly
for
have
supply
the
of- just a
earlier
minute.
order.
You just tell us. This
But
is-
the earlier order was, that is at page 335. Various prayers were made, my lord. I must tell my lords, there were 5 prayers made before that honorable court. And that, if my lords may, there is
Just let us first see.
yes,
read this.
kindly
Do
have
not-
page 335,
See, before
annexure 10. I'll read from para 3, page 335.
Just a minute. Let 335.
Yes, my lord. It's dated 10th of August 2022.
Yes.
I'll read from para 3, my lord. The learned counsel for the petitioner has submitted that pursuant to the relevant order passed by this court, the investigating officer has allowed the petitioners to peruse the voluminous documents and to sort out the relevant documents, for which copies of the same be given to the petitioners. In this regard, the petitioner has submitted the IO has had a meeting with them and some relevant documents have been identified. However, to complete the process, may take some time. This being the primary prayer of the petitioner, the learned counsel has submitted that the other prayers would not be pressed if this court direct the concerned IO to cooperate with the petitioner and to supply the relevant documents and papers entitled to them. In the meantime, until the said process is completed, the proceedings before the trial court be kept in abeyance, as was done so by the interim order of this court. Mr. K. Khan, learned counsel, PP, in all fairness, has submitted that the state respondent would have no grievance to the prayer made by the petitioner herein, and to this extent the petition may be disposed of accordingly. On consideration of the submission made, without going into the merits of this petition, this court is convinced that this petition may be disposed of on the limited prayer made. Accordingly, the ongoing process of identification of the relevant documents and papers entitled to by the petitioners, for which the IO is directed to sort out and hand over copies of the same to the petitioners, and on completion of the process be continued, with the report to be filed before the trial court for continuation of the proceeding after the same is completed. However, the IO is directed to complete the process preferably within a period of 3 months. In the meantime, as prayed for, the related proceedings before the trial court is kept in abeyance. Then I moved an application, my lord, because they were not filing a report. They were not even giving me the documents. Then kindly have the...
Just pause for a minute. Yes, now, what needed is that identification of documents. Now, identification of document was to be done by...
And the supply.
Wait. Supply will come once you identify, isn't it?
Yes.
You identify, then you ask for supply.
We did.
Wait. Let the court complete the query.
Yes, very.
What is the hurry?
I apologize.
Now, how many documents you have identified?
We identified plenty of them.
Where are those? Where are the list of those?
There is no, that's what the whole, what I'll tell my lords, I went to the Malkhana. Kindly hear me, because that is part of the impugned order, page 356.
We are in a read jurisdiction.
Yes.
What actual aspect takes place will be quite difficult.
Kindly have then 356, the order, impugned order. Relevant is that starts from 357. Yes. This is the impugned order dated 26th of June 2023. CR put up today before me along with other application number 15 of 2023. Other application number 15 fixed for orders today. Heard learned counsel for the petitioner D.K. Datta, who submit that as per the arguments made in the petition, which are as follows. That the petitioner Shri CM Jha is represented by his duly appointed attorney Shri So-and-so. That the documents as per list annexed hereto and marked as Annexure 1 are hereby produced before this court in compliance with the order dated 10th of August 20 passed by the Honorable High Court of Meghalaya.
What is the Annexure 1?
Annexure 1 is, my lord, kindly have the same...
What are those documents?
The documents are all appended here. Here also. They are all voluminous.
What is the problem in saying these are all identified documents? Or
these are all the identified documents.
Say that.
Very well.
Why you do not say? Why you do not have a direct...
Annexure 11. Annexure 11 are all the relevant documents.
So that means those are the documents which are identified.
Yes.
So you want those documents?
Yes.
So those documents were not given to you?
They were not given to me.
Where is that annexure?
The annexure 11.
What is the page?
Page, my lord, is 338.
Yes.
They are all documents.
Now these are the documents which you want copies.
Yes.
Yes. Why? Once the court earlier order has said, identify the documents and supply. You identified the documents. A list was submitted, but then yet you have not supplied it to them. Why?
Lordship had submitted the report last time. Lordship, can you see
what you are saying? You have submitted. You have already supplied him all those documents, which are reflected at page 338.
Not everything, Lordship.
Why not? That is what is required by the earlier order.
Yes, that is correct.
Then
that is correct.
Then you are bound to do it. You do it. How long it will take to do it? Which are the documents? All these documents are not supplied, or
no, my lord. There are some documents which the rats have eaten, but in the Malkhana it was all in a disarray.
What can be done in such a situation?
But all the documents exculpatory.
If you are demanding production of some documents which are not in existence, then what?
They are in existence. What happened? There are another set of story, my lord. They told me, the investigating officer said that the main hard disk which contained all your documents have also been corrupted. The copy of the same which was with the FSL also been corrupted. The one created with the CD is also corrupted. So we can't give it to you. So I said, give me everything else.
Wait. Whether those things were communicated to you?
No.
In writing?
No, not at all. That's the whole ground, my lord. I raised it in before the trial court also, that the documents are not being given to me.
Have you said all those things in your writ petition here?
That's exactly.
And what is their reply to that?
They kindly have their reply. They conveniently say it is all a matter of record. Have their say also.
Now what you are saying, that in spite of the availability of these documents, they are declining to supply it to you.
Yes.
Is it the case?
Yes. Kindly have their say also. They say it at para 16 that with regard to the arguments made at para 340 of writ petition, the answering respondent submit that the seizures along with the so and so correction are enclosed along with charge sheet. That with regard to arguments made at para 2.4 and 2.
What is your statement?
The entire document, the answering deponent has no comment to make.
let us first come to your statement.
Yes, kindly have my statement, page para 2.41. Page 23. Page 23 of my writ petition, my lord.
23.
Yes, 23. Page 23 of the main writ petition. Para 2.41.
Yes.
That in the above circumstances, when the application for discharge filed by the petitioner came up for hearing before the trial court on 25th of 11/2019, the counsel for the petitioner pointed to the above fact and the manner in which the investigation officer is acting in prejudicial manner against the accused person. The counsel for the submitted before the trial court that when bias is alleged against the investigating officer, the investigation conducted so far as against the accused person is a tainted investigation. No trial could be proceeded on the basis of the tainted investigation by which the investigating officer had withheld the documents which would exculpate the petitioner from the alleged offence. It is therefore necessary to bring on record the list of documents which is furnished to the trial court, or otherwise the accused person would be denied a fair trial and the trial would be conducted on the basis of the tainted investigation. That tampering with the important piece of evidence is another matter which frequently is resorted to by the police during investigation which affects the prosecution case. In the present case, the respondent investigating
just withheld the documents which would now whether those documents are mentioned in that page 338.
Yes.
What are those documents?
These are, my lord.
This is not.
I'll tell my lords what are those documents. I'll tell my lords in a journal off the cuff only. I'll tell my lord what are those documents which are being withheld.
We'll come back.
No.
We'll come back.
Very well. Since my learned senior is here, my lord, now my learned senior can take it.
There is no problem in it. Mr. Mohanty, you have to wait to sit in division bench first and then.
Grateful.
See, make it simpler. You see, useless going here, there, and all those things. If issue is that issue is confined to that the order passed by earlier round of litigation has not been complied with, let us confine to it. And if you say that is the list, and this is the document identified, identification means joint identification. Yes. You just cannot come and enclose something which is not at all available. So now, if they agree that this is the list, which was identified jointly, then in such a case their duty can be disposed. So that is do not make it make the thing complicated. It's not required. And at least this court will not like you see like going there. And if you have any other issues and all, then you will get this better listed before that court. We will say that in such a case you are seeking implementation of the order which was passed by that court, and in that view of the matter this will be listed.
No, I think actually your lordship has mentioned since earlier they also said these are records, documents or the records, and they can supply it.
Grateful.
Chalo,
7.
Shri Mahanta does not have any problem, my lord, if the same order is passed, my lord, allowing us to go and get the documents.
If in case we have to just see what is the stand of the state.
The state stand is also recorded, my lord, in the impugned
It's okay.
order.
Let them come and submit
Very
it.
well,
See,
very
that was stand before that court. If they say that they will supply it, we'll record it and then.
Very well, very well. I'm so grateful, my lord.
If you want any kind of interpretation of the earlier order passed by
No, my
this
lord, there
court,
is no.
then in such a case, we'll place it before the Honorable Chief Justice.
No, my lord, I did not had any intention to, my
No,
lord,
it is
say
not
anything
that.
like
It is
that.
not that actually. But then this also will not be proper for this court to interpret the order passed by another court.
My lord, the trial court did interpret the order.
That is for them. See, whatever they do.
So the only thing, my lord, that order need to be set aside. Otherwise, the trial court will say that order stands as it is.
What is the trial court's
The
order?
trial court, my lord, says
What is the last trial court order?
the my lord starts from page 357.
Just a minute. Where is Mr. Khan? Yes.
359 is the relevant portion, my lord, para 17.
Yes.
On the bare reading of the above mentioned paragraphs in the order dated 10th of August 2022, what this
10th of
court
August
could,
means the High Court's order.
yes, High Court order, could humbly understand is that through the said order, the Honorable High Court of Meghalaya has directed the IO to sort out and hand over the copies of the relevant documents and papers entitled to by the petitioner to him, and on completion of the process to be continued to file a report before this court for continuation of the process after it's completed. There is no report filed by the IO before this court that the process of sorting out and handing over relevant documents and papers to the petitioner is completed. Moreover, the learned counsel of the petitioner has also verbally submitted before this honorable court that the IO has not handed over all the documents to the petitioner till date. The order dated 10th of August of 2022 of this honorable court of Meghalaya does not direct the petitioner to submit any document before this court. Moreover, the learned counsel of the petitioner not submitted anything on the previous order and provision under which this court can accept production of any document on behalf of the petitioner at this stage when the trial of this case has not commenced. In consideration of so and so made above, the instant petition is hereby rejected.
What is that paragraph 19? What does it say? The order is done by the petitioner.
Petitioner is us, my lord.
To submit any document before this court. Yes. Most of the learned counsel of the petitioner has not submitted anything in the.
And it rejects my application for either allowing.
No, that is, see, there was nothing.
We made twofold prayers in that application. One was for allowing us to produce those documents because they are not being.
No, that is a separate issue. Why
And
are you connecting
secondly,
with this?
And secondly, the report be filed.
See, you see, then if you say there are 2-3 issues, then definitely.
No,
you
the
cannot
trial
dispose
court,
of- see, here, if you take totally the shelter of the earlier order pass, then it is confined to the
Para 18, my lord. Yes.
identification of documents
Yes.
and handing over.
Yes.
Nothing beyond that.
Nothing beyond.
Now, if you say that, or if you try to assert any right with regard to your right to produce some documents and all, that is a
No,
different
not at all. I did not want you to produce anything. Rather, what I said was that if they are not doing it, allow me to do it, because the court also records. The court record they are not doing it.
That also will go against the terms of the High Court.
Very well. Para 18.
High Court could not have done it.
Para 18 says the report has still not been filed.
That is what. That is why I make out a case.
Great.
Yes.
Your Honor, Safhan engaged in another.
So, then what is to be done?
Your Lordship may take up this matter at the end of the morning, right?
We were in the midst of this, so we are not going to this. Tell somebody else to stand up.
Your Lordship,
We cannot stop this court from passing order just because of the fact that lawyer is standing outside in another court.
Your Lordship,
So none of the documents mentioned at page 338 was handed over to you.
No, ma'am. No, my lords.
These are the identified documents.
Yes, these were the identified
There
documents.
means no dispute with regard to that. These are the identified documents.
There were others also which were.
That is why you see this
No, no,
other side counsel was
it's in
needed,
the.
you see.
No. What had happened was there were two malkhanas for me. One key was not located because the IU had changed.
And this is why we want this court to go.
But I am only bringing on record the actual facts
See,
of the case.
we'll pass order basing on the
Very well. All identified documents.
Those sexual aspects will not be.
Very well.
See, what happened there? What is the reason for non-supply? We do not know.
Let it be supplied.
Once court says you supply,
Yes.
they will have to supply.
I am so grateful, man. This is all we
If
want.
there is any serious difficulty, they should come and seek modification
Yes,
of the order.
I only want this much. My learned senior is here, my lord. He can.
Mr. Mahanto,
Yes, that's what I did. Only we need to read that.
Mr. Mahanto, is it the fact that this is admitted document, this 338?
Yes.
That these are the.
Yes,
See, in absence of that, you say like that is a problem, you know. They are there.
Only to comply with the previous order of this Honorable High Court, Your Lordship, that will suffice, I think, the entire matter.
Are you saying this is non-compliance of the previous order?
Yes.
So if you say
That was not
non-compliance, then matter should go before that court.
No, but still here we are making a very simple prayer, Your Lordship, that those documents which we have here identified are to be supplied. And there is a part of the record they have stated in the affidavit.
You know, what this court at this stage wants to know whether these documents at page 30
Yes,
are admittedly identified documents.
identified and part of the records.
That is what just we needed
Yes.
to record their submission, nothing else. If Mr. Khan is not there, then again
But he is not denying that in the affidavit.
he is probably not properly instructed to do it. Are you a government lawyer?
No.
See? And this now 4 courts are sitting together. That is also one
I
aspect.
know.
We can have it tomorrow.
Tomorrow. As Your Lordship, please. As Your Lordship, please. But this is only very simple. I think Mr. Khan also, senior counsel, I think he admitted in the affidavit. It is there. In the affidavit, it is there.
And then we
Only that part.
court records his presence, you see.
Of course. Yes.
Or we can try at the end of the vote if you. Then how many matters we have, madam? Only one matter.
Then if Lordship permits, I have to go to hospital, so he'll be there. He can walk.
So then we'll have it tomorrow.
Or today it can be finished.
Otherwise, have it after this matter, my lord. He may come because there's only one matter.
Only taken after this thing. After this thing.
Lordship will permit me to leave here.
Yes.
I'm deeply obliged.
Second call, item number 3.
Yes.
I have a small prayer, Lordship, if this matter can be taken up on Monday next, Lordship.
It is a big prayer. The court had rejected your prayer of adjournment. So it is no more a small prayer. So these are old matters.
Lordship,
Court
I
has
understand, Lord.
indicated to you several times that this old matters court is not very much inclined.
Lordship, may I have it on Monday, Lordship. Learned senior will be here, Lordship. We'll make an endeavor, Lordship, next week to take up this matter.
You are appearing for?
8 and 9. We're just perform respondents in this matter, Your Lordship.
Who is state? State is the main respondent here.
Yes, Lordship.
State is represented by Senior Advocate Mr. Khan.
Nobody is there for the state.
No,
Here.
No, Lordship.
No one is there for the team.
No one.
Yes, I heard Mr. So-and-so. Oh, Mr. So-and-so is present for the petitioner. None appears for the state respondents. His name, record his names. First say so-and-so appears for the petitioner. So-and-so present. We have the respondent number, so-and-so. Okay, none appears with this instance. This is matter. When do you want?
After a week, Lordship.
This is matter.
Bless you, Lordship.
Now we get advantage because none appears. At least state should at least make one counsel present. This is not.
7.
Yes. See, it's coming back again now. That is, they should make somebody. See,
Somebody
if this
yes.
matter is not very complicated, at least somebody instructed should be in there. There are many panel lawyers here.
I know. But even me, I had a matter in Justice Triangle Court, but
We'll
like
have it
that
tomorrow
was-
then. We'll have it tomorrow, Mr. Jalal.
As you.
You will be here if you want to say.
Yes.
If matter is things,
That's right.
just say, art so and so so and so. None case for the state. List this matter. Tomorrow, give this.
Diplomas.